Yes, it is. So welcome to this fourth panel. We will be discussing corporate governance and corporate reporting. And I have on my right-hand side, Professor Madalena Portugal de Oliveira. Well, she doesn't need any presentation, but she holds a PhD in law from this law school. And she's an assistant professor here at this university. And she's a researcher at the Private Law Research Center. She's also a senior consultant in the banking and finance and corporate M&A areas at the renowned law firm PLMJ. And she will be addressing the corporate governance topic. We have online Professor Filipe Cerqueira Alves, who's also holds a PhD from the Portuguese Catholic University, and also it's also an assistant professor there, also a lawyer, and he'll be addressing the corporate reporting topic. And following these two presentations, then we will have room for comments. On my left-hand side, I have Paulo Câmara, an invited professor at the Portuguese Catholic University and Lisbon MEA, and partner at the renowned law firm Servo. On our right-hand side, we have Bruno Ferreira, who will be also commenting on these two presentations. He holds a Master of Laws from this law school and is a managing partner of the renowned law firm PLMJ. And so without further ado, I would give the floor to Madalena. Please go ahead.
Thank you. Good afternoon, everyone. So let me start by using the challenge that Colin Meyer uses to start his brilliant book, Prosperity. So the law is to justice, as medicine is to health, as business is to how would you complete the sentence? So if you are sitting here today in a conference about corporate environmental responsibility, I can guess that your answer will be something along the lines of Colin Myers. So the law is to justice as business is to prosperity. However, we still read and hear corporate law scholars state that there is one and only social responsibility of business: to use its resources and engage in activities designed to increase its profits, so long as it stays within the rules of the game, which is to say, engages in open and free competition without deception or fraud. Many of you know this theory. This is the Friedman Doctrine, and it argues for the maximization of shareholder profit and is rooted in what's known as agency theory. At its core is the assertion that shareholders own the corporation, and as owners, shareholders have ultimate authority over the company's business and may demand that its activities be conducted in order to maximize their interests, so profit. According to these theories, directors are simply agents to shareholders, which means that they have a direct responsibility to their employees, shareholders, to run the company in accordance with their wishes. Social responsibilities should lay with individuals acting as principals and not as agents. But the Friedman Doctrine is not a law of nature, and we need to challenge the shareholder-centric model of corporate governance. Its matter of maximizing shareholder value has put our companies, has distracted our companies from innovation, strategic renewal, from investment in the future. The fact that the idea that shareholders own the corporations is confusing, to say the very least. They are only beneficiaries of a company's activities. They are physical, shareholders are physically and psychologically distant from the companies they invest in. And that can be illustrated by several arguments. One, the anonymity afforded to shareholders, to shares beneficial owners, is an example of that mitigates the relationship between shareholders and its companies. Two, the high turnover in shares means that asset managers make decisions driven by short-term expectations. Three, even though shareholders may vote on general meetings, they can use their voting rights in whatever way they deem appropriate. And four, the fact that exit strategies are easier than the voice ones, and the fact that Phenomenons like empty voting exist confirm that shareholders are detached from the companies they invest in. Having this in mind, we should make way to a company-centered model of corporate governance. We can say that the company is an entity in itself and that managers are fiduciaries to the shareholders and not their agents. And the difference is not merely linguistic, the difference is stark, because fiduciaries, an agent is an order taker, whereas fiduciaries are expected to make discretionary decisions. And so purpose-driven leaders are faced with a big challenge. They need to know, is it possible to favor purpose over profit? And is it possible to do well by doing good? There is a widespread idea that being good and doing well in financial terms may go hand in hand, and sometimes they do. This is the business case for sustainability, which is metaphorically presented as a virtuous cycle. And this is also the assumption behind most corporate law articles, most corporate law papers. However, and this is also the case behind the letters to CEOs by Larry Fink that are very well known. As many of you know, in 2020, Larry Fink wrote that, and I read it, each company's prospects for growth are inextricable from its ability to operate sustainably and serve its full set of stakeholders. And he also wrote that a company cannot achieve long-term profits without embracing purpose and considering the needs of a broad range of stakeholders. Ultimately, purpose is the engine of long-term profitability. And in fact, it is true that some studies show a positive relationship between sustainability and financial gains. Some studies show that employee satisfaction can increase shareholder return. However, I believe that the defense of a model of stakeholderism needs to acknowledge that this relationship is not always established because not all studies support these conclusions. And to a certain extent, I would say that this dilemma has been played out by Larry Fink, who's a great advocate, as I've just said, of responsible capitalism. But the truth is that faced with the rising energy prices, BlackRock announced that it was likely to vote against shareholders' resolutions pursuing a ban on new oil and gas production. And why? Because responsible investors who underweight oil and gas production, oil and gas investment, of course, have underperformed traditional investment funds. And so when sustainability and profit are not aligned, many sustainability-friendly investors or apparently sustainably friendly investors seem to question the strategy precisely because the most sustainable path is not always the most profitable one. So attempting to cloak sustainability under the guise of the pursuit of profit does very little to advance the discussion around corporate sustainability. The path to a stakeholder-friendly governance model requires the assumption and the acceptance that not all decisions that put the interests of stakeholders first are beneficial to shareholders. The Business Roundtable statement on the purpose of corporation, adopted in 2019 and signed by 181 CEOs, marked an important step towards recognizing stakeholders' interests in corporate governance. And what happened is that in this document, several companies declared their intention to serve and create value for all stakeholders. And according to the movement, and the movement was led by CEO of BlackRock, by CEO of JP Morgan, and CEOs who signed up committed to lead their companies for the benefit of all stakeholders: customers, employees, suppliers, communities, and shareholders. This statement caused a great stir among the international community, especially considering the order in which stakeholders appear. Let me say it again: customers, employees, suppliers, communities, and shareholders. Shareholders coming last. So looking at the Business Roundtable statement, we should ask, what does it mean to create value for stakeholders? It is debatable whether a model of instrumental stakeholderism or pluralistic stakeholderism should be adopted. Instrumental stakeholderism recognizes that directors must consider the impact of their decisions on stakeholders in order to increase shareholder value. Social responsibility represents a business opportunity to do well by doing good. And this theory corresponds to the idea of enlightened shareholder value. It is not substantially different from shareholder value. It merely acknowledges that pursuing shareholder value may entail tackling ESG concerns. So despite this, despite not being substantially different from shareholderism, I believe that there are advantages in advocating for this model. The theory emphasizes the role of stakeholders. This has an informative, has an educational value, which may ultimately promote better corporate decision-making. On the other hand, pluralistic stakeholderism considers the well-being of stakeholders as an end in itself. It is up to the board members to decide how to allocate the value created by the company by dividing it between shareholders and stakeholders. Directors take on the role of mediating hierarchies. However, it is not clear in this model of corporate governance if directors may consider the stakeholders' interests, or on the other hand, if they must do so. So when I'm discussing stakeholders, I'm thinking about those who are affected or who affect the company and the company's activities. And when debating the need to protect stakeholders, I am mostly thinking about non-contractual stakeholders, because stakeholders who have a contractual relationship with the company can protect themselves through the contract. There are some stakeholders with so much power over the company that they even qualify as de facto directors. Regarding those stakeholders who do not have a prior relationship with the company, those are the ones that need protection. And the board of directors' fiduciary duties mean that they need to know, the board of directors need to know the company's stakeholders in order to consider their interests in the decision-making process. It is sometimes argued that the move towards corporate sustainability involves introduction of the so-called purpose clauses in the Articles of Association. Purpose clauses are provisions that lay down the company's purpose and bind corporate bodies to fiduciary duties in promoting it. And these clauses serve a dual purpose. On the one hand, they limit the type of behavior that can be adopted in the pursuit of profit, and on the other hand, they are a way for companies to commit themselves to certain objectives that may be in the public interest. However, it is debatable whether corporate law should impose these purpose clauses, or instead if it should nudge shareholders to force or to nudge companies in the direction of promoting their corporate purpose. And especially, there is the big risk that these purpose clauses turn into empty clauses. In this regard, it is good to remember that in the mid-19th century, in response to the granting of limited liability, company law required companies to declare the areas in business in which they were to operate and the powers they were to have. Under the ultra vires doctrine, transactions outside the scope of the business were considered void, and directors could be held liable for damages caused by such void transactions. So, in order to avoid this scenario, what happened was that most companies began to draft their articles of association in such a broad and general terms that they could cover any possible activity. Soon after that, companies were no longer required to define their proposed object. So, does this mean that purpose clauses are useless? I believe not. They may have the virtue of establishing what is out of bounds in determining legitimate sources of profit and providing a means for companies to commit to the delivery of public benefits. There are many companies that present their purpose, their mission, their values. It is the case for Adidas, Michelin, Google, Danone. And the idea of purpose clauses has been adopted, has been implemented in several countries. It is the case for France since 2019 in the Loi Pacte, law to the croissance et la transformation des entreprises, that amended the civil code to provide that the company's articles of association may specify a raison d'être consisting of the principles which the company adopts and for the respect of which it intends to allocate resources in carrying out its activity. At the same time, in France, the civil code was also amended, adding a paragraph according to which the company is managed in its social interest, taking into account the social and environmental implications of its activity. In Portugal, we also have an equivalent provision in the Portuguese Companies Code. But even though these rules grant directors a broader decision-making room, they don't implement a model of pluralistic stakeholderism, because the interests that must be considered first and foremost are still the interests of the shareholders. So one question arises: would it be helpful to amend corporate law to ensure that directors' duties are first and foremost focused on the company's purpose? To some degree, this would nudge directors in the right direction. If directors had a fiduciary duty to uphold corporate purpose, then they could be held accountable for this delivery. If purpose had a normative component of doing good, as well as a positive component of making a good, then directors would in principle be obliged to promote a social as well as a private benefit. However, there are 3 reasons why in practice this might not be quite as significant as it initially looks. The first is that in private corporations, it is up to the shareholders to seek a remedy for a violation of a breach of a fiduciary responsibility. The imposition of a public purpose is therefore dependent on the shareholders' willingness to do so. If shareholders are only self-interested in their financial earnings, even if corporate purpose were more prominent in company law, its enforcement would remain weak. Secondly, shareholders do not, in general, sue their directors. It is regarded as a complex, expensive, and largely self-defeating exercise. Thirdly, there is one reason why the law is not decisive in this matter: the market for corporate control. Directors fear the wrath of shareholders through their direct engagement more than through the courts. What influences the most directors' behaviors is the telephone call from an activist investor, backed by this possibility of a resolution at a shareholders' meeting that threatens the survival of corporate directors. The impact of shareholder activism on boards cannot be ignored. And the rise of the so-called wolf packs, which are groups of activist shareholders working together to gain control of a corporate body, for corporate board, has resulted in the appointment of blockholder directors selected by these insurgent investors. So these powers translate into purpose, because those who run corporations owe their continued employment as managers and as directors to the only constituencies that the corporate law establishes, and those are stockholders. That is why the proposal for an EU directive about sustainable corporate governance could be important. In a European context where a shareholder value-centric model still prevails in most countries, it is important to ensure that director duties go beyond mere reporting, mere ticking the box exercises, and engage with stakeholders. And what about Portuguese law? Under Portuguese law, under Article 64 of the Portuguese Companies Code, the administration should pursue the interests of the company, meeting the long-term interests of shareholders and considering the interests of other constituencies relevant to the sustainability of the company, such as its workers, customers, and creditors. This legal formula is not committed to a model of shareholder value. It's compatible with a corporate governance model which values the role of other stakeholders. So Portuguese law commands that directors pursue the increase of the corporation's long-term market value, clearly seeking a balance between shareholders and stakeholders' value. Pursuing profit comes together with creating value for stakeholders. In other words, if there are 2 courses of action that are reasonably compatible with shareholders' interests, the company must choose the best solution for stakeholders. And even if that solution implies less profit for shareholders. For example, a less polluting process should be chosen even if this implies higher costs and lower profits, as long as financial sustainability is granted. However, directors may not pursue decisions which imply that they depart from shareholders' interests, which are mainly profits. So Portuguese law recognizes that it's not the idea, that is not the notion of making profits that is at fault. The source of corporate failure is the way that Friedman doctrine has morphed into an obligation on companies to achieve greater profits than other firms at all times. Having this in mind, I ask again, would it be advisable to change corporate law? I believe there is no need to. If purpose is included in a system which remains institutionally wedded to shareholder value, it will not turn the tide on corporate activity in the direction in which purpose intends to point it. We need to get closer to the core of the issue, and the core of the issue is the governance of corporate purpose. I believe it is of paramount importance to align directors' and stakeholders' interests, and I believe regulation isn't enough. The pursuit of sustainability requires a general change in corporate culture. We were speaking about that in the last panel before lunch. It also involves accountability, which means that the specific people should be responsible for this goal. This plays into the hands of adopting a corporate organization and appointing, for example, chief sustainability officers, having ESG working groups, having sustainability committees, internal or external ones, thinking about directors' expertise and skills in boards. So besides diversity in gender, we should think about expertise in sustainability, in climate law, in climate, in ESG issues, etc. But as Colin Meyer states, being a responsible businessman is not straightforward. Money and morals are not natural bedfellows. It is easy to say that one does well, makes profit by doing good, being socially responsible, but the truth of the matter is that one often does a lot better by doing bad. So the fact that markets have no morals, combined with the conclusion that short-term self-interest institutional investors are the masters of corporate decision-making, makes it difficult for the board to pursue the company's purpose. There is evidence that there are three aspects of management that are associated with doing well by doing good: purpose, practice, and performance. You must want to do it, that is purpose. You have to bring others along in doing it, that's practice. And you have to demonstrate you have done it, that's performance. And performance is an element that presents significant challenges. We know how to measure profits, or at least we think we do, but we do not know how to measure much else. It is much harder to measure such nebulous concepts as human well-being, social capital, and natural capital, or at least to attach a monetary value to them with the same precision as we do with profit. So I would like to end this presentation with yet one more provocation. Maybe in the future, we will not ask whether directors owe a fiduciary duty towards the company and other constituencies, but if shareholders, at least the controlling ones, who exercise a significant influence over the company, are bound by fiduciary duties towards the company and its stakeholders. And maybe only then can we go from good intentions to commitment. Thank you.
Thank you very much. It was very enlightening. Are we supposed to give the floor to comments now or in the end? What? In the end. Very well. So now I'd give the floor to Professor Filipe Cerqueira Alves, who will be addressing you from Porto. Can
you hear me well?
There we go. Welcome.
Okay. Do I have the floor, Professor?
Yes, you do have the floor.
No, thank you very much. Well, good afternoon, everyone, and thank you so much for having me with a bittersweet feeling. Well, I am very thankful to joining you. I'm sad I cannot be with you in presence, but at least now we have online that allows us to bridge those differences and the distance as well. I would like to begin by saluting, of course, our dear panelists and thanking the organization here represented in this panel by Professor Madalena. Thank you very much for having me. And of course, the institutional organization is also to be commended. I was not prepared for such a brilliant opening, such as Professor Madalena, with in particular book quoting and book showcasing, although I do reach out to my bookshelf right behind me, which cannot be seen since I have a lovely background. And I did manage to find maybe here Ronald Dworkin with Justice for Hedgehogs, which is the edition, of course, we cannot see very well, by Almedina, our editor. It sort of portraits the long-standing relation between law and environment, at least. That's the best that I can do for now. I'm sorry that I cannot do any better. Well, thank you so much for the initiative to allows us to gather here and share views, gather input on up-and-coming matters of utmost relevance, both for our community in general and to anyone interested in corporate matters in particular, by reference to this panel. So without any further ado, I will address my subject now, corporate reporting, not without mentioning that this presentation is also the outcome of research that was conducted together with Professor Maria Fátima Ribeiro from Portuguese Catholic University, Universidade Católica Portuguesa, also here from the School of Porto. Well, such an apparently dull subject, corporate reporting, and apparently unrelated to sustainability. I mean, how can reporting of corporate matters improve or bear significance to sustainability matters? Many can pose this question, but I would like to reverse it, such as the previous speaker did in its final remarks. How do sustainability matters bear significance to corporate reporting? This would be my departure point. Quite a lot, actually, especially here in the EU, since the entry into force of the Directive 2022-2464. We will refer to it simply as the directive. It is the Corporate Sustainability Reporting Directive of the European Parliament and the Council, which introduces new rules on corporate sustainability reporting, entered into force on the 5th of January 2023 and shall impact mostly financial years beginning on January 1st, 2024. The main goals of the reporting directive are to increase the number of companies that are covered by the reporting regime and the detail and extent of ESG disclosures, environmental, social, and governance disclosures. We know the acronym by now, especially to increase the detail and extent of these disclosures that will have to be rendered public, especially when compared to the requirements of the previous EU directive that addressed this issue, which was the so-called non-financial reporting directive. Which can also be addressed to as the accounting directive. The significant majority of these new features have been introduced by the new reporting directive through amendments to several directives. I think it would be cumbersome to list them all. I would focus mainly on Directive 2013-34, which is the so-called accounting directive. And so the reporting directive is expressly aimed at reaching two groups of users. Investors, first group, who want to understand risks and opportunities that sustainability issues pose for their investments and the impacts of those investments on people and the environment, and civil society actors, including non-governmental organizations and social partners which wish to better hold undertakings to account for their impacts on people and the environment. So, and I'm quoting here the recitals of the directive. While the use of data reported by the former might impact the traditional stakeholders of a company and their interaction and mutual relations, it is the use of information by investors that can pose new challenges, also especially concerning perception of the actions of the company. It must be noted that the amendments to the accounting directive are clearly based on a political steering mandate, let's generally say of the EU, to change corporate culture and the framework of financial reporting, and should be understood within this context. Not surprisingly, with the adoption of this directive, the EU legislator is being accused of further restricting the private sector's decision-making margin in order to orientate supply and demand in financial and performance markets towards green and socially beneficial, here between commas, channels. So this would be the first point that I'd like to stress, that of course this directive is not, let us say, received by the broader community without harsh remarks. The directive also aims at a shift of paradigm on what concerns the relation between investment and sustainability. This is clearly demonstrated by evident terminology amendments. So for instance, the term sustainability information replaces the term non-financial information previously developed under Article 29A of the Accounting Directive. So where previously we had non-financial information, now we have sustainability information. Sustainability information encompasses environmental, social, human rights, and governance factors. Due to several cross-references to other EU legislative documents, also employee matters, anti-corruption, and anti-bribery matters are also bridged by what are the so-called sustainability matters. And recital 8 of the reporting directive notices that such change in terminology is aimed at portraying the financial relevance of such information. So sustainability information cannot be understood as non-financial. The change in terminology seeks to convey a change in purpose. Sustainability information is also financial information, so hence the change of terminology. Let's jump to answering the question, who is forced to report? Well, the number of companies that will now be required to report detailed ESG information in the European Union is widely extended. Also, insurance undertakings and credit institutions under certain conditions are now also under the scope of the directive. And these reporting requirements will apply to large undertakings and to small and medium-sized undertakings, which are public interest undertakings, as the accounting directive defines them. So let us not try to be excessively detailed. Let us just say that a large undertaking exceeds at least 2 of 3 criteria, a total of 20 million euro balance sheet, or of net turnover of 40 million euros. Or, for instance, this is more relevant, I'd say 250 employees during the financial year in question. Let us note that the previous version concerning non-financial reporting only considered large undertakings, public interest entities, which exceeded the criterion of average number of 500 employees during the financial year. So this threshold is quite lowered. Of course, numerical quantitative thresholds also define what's a medium-sized undertaking. This can be easily consulted by checking the directive. I don't think it's of much interest to develop them here, but we would also stress that public interest undertakings, which do not fit exactly these thresholds, are also forced to report, and these include listed companies on regulated EU stock markets, or specific financial services companies, or companies designated as so by a member state. Also, undertakers established in the EU that are subsidiaries of branches of an ultimate parent company established outside the EU may be required to issue the report in relation to the whole global group. So this means that the EU, under the reporting directive, might, well, force perhaps is a strong word, but intends on making the non-EU group undertakings that have no activity in the EU, this information to be included in an undertaking held by a non-EU entity that is operating in the European Union. So for this to apply, the third country undertaking, let's call it the third country undertaking, at the group level must have generated a net turnover of more than 150 million in 150 million euros, sorry, in the European Union for each of the 2 consecutive financial years. So we have here relatively mid-sized undertakings already encompassed by this reporting obligation, and we have as well EU undertakers and undertakings and non-EU undertakings. Second question, what will be reported? Well, whereas the previous version of Article 19A of the Accounting Directive demanded that a non-financial report describes the undertaking's business models, due diligence processes in relation to non-financial matters, and outcomes and risks, the new version, amended by the Reporting Directive, is much more thorough. It demands reporting on business opportunities, business strategies in the fields of sustainability matters, as well as specific plans of the undertaking, including implementing actions related financial and investment plans to ensure that all the aforementioned the strategies and opportunities are compatible with transitions to sustainable economies and other goals. This will imply tangible planning in these matters and will demand that such tangible planning is a part of every undertaking's annual budget. Also, it is demanded specific time-bound targets for implementation of these targets and associated progress reviews. So what we have here is already certain demands that impact the budget planning of the undertakings that are forced to report. Their organization is also to be impacted, since it is now demanded that the reporting of sustainability matters describes the role of the administrative, management, and supervisory boards with regard to sustainability matters. Also, their expertise and skills in relation to fulfilling that role, or the access that such bodies have to such expertise and skills. This might be outsourced, as we'll soon see, but the duties of developing and implementing such skills are still bear upon obviously the corporate directors. What information is to be required is not specifically detailed. It is rather to be developed in the Union Sustainability Reporting Standards, which are set to be adopted by the European Commission, taking account of technical advice that the European Financial Reporting Advisory Group will develop. On July the 3rd, the first set of standards was approved by the European Commission. It includes 2 groups of standards, cross-cutting standards, general requirements and general disclosures, and standards on environmental, social, and governance matters, which include, for instance, disclosure concerning resource use, circular economy, own workforce, description of employees and their functions in the value chain, affected communities, and other type of information. So let us say that implementation of such standards is also impacted by the need of developing the expertise and tools that is necessary for reporting, auditing, and supervise this report, as well as enforcement capabilities for the authorities that wish to enforce, that wish to audit the accomplishment of the reporting measures. So the task within the EU is far-reaching and will demand serious improvement both of normative text and public and private institutions to be effective. What should also be noted is that EU undertaking reporting standards go beyond other jurisdiction reporting standards, in particular the US reporting standards. Compliance costs associated with report are non-neglectable. And let us say that at the expense of private initiative, the EU might be imposing compliance costs and obligations that seem to have a broader societal purpose and can pose, let's say, a challenge to corporate nature and to corporate purpose as we have been understanding it, at least in an evolving nature up until now. I am bound to conclude. I will take final remarks, which are not final. It's the last third of my presentation, but concerns the impact of the described changes that the reporting directive now brings. I will try to bridge them, not to be too cumbersome. First and foremost, governance of undertakings, as previous speaker was mentioning, and the relation between the board and shareholders is to be effective. From the outset, the content of the sustainability report demands adherence to due diligence procedures of identifying a framework of a business model and associated sustainability risks related to the business model. So such duty must be fulfilled with detail. The degree of detail demanded by the reporting obligations goes as far as demanding the description of tangible, concrete implementing actions, and related financial and investment plans. We can only fulfill this task if tangible risks are identified and specific measures to contain or address them are considered. And subsequently, the reporting standards demand that the corporate bodies have specific skills that allow them to fulfill these functions associated with sustainability reporting. Firstly, such skills will, of course, demand specific training, and such specific training will probably embed sustainability concerns within the decision-making of every board and its procedures. While it is true that the provision Article 19A, paragraph 2nd, subparagraph C of the Accounting Directive allows, or it can be argued that allows for outsourcing of such expertise, penalties, responsibility, and liability for defaulting on these obligations of report does not fall on outside counsel, rather falls on the board and supervisory members as pursuant to Article 33 of the Accounting Directive. So sustainability matters become an issue of primary relevance to be addressed at the board level, but not only at the board level. Indeed, the reporting will impact organizational culture. Sustainability data is necessarily provided from the bottom to the top. So this will lead to dissemination of awareness for such issues throughout company structures. Data outputs that might inform report drafting will need to be collected and monitored, which demands upstream preparation of such information flow. Internal controls and data management procedures will need to be implemented to comply with the reporting obligations, and this flow of information will always need to be available for auditing purpose. So, of course, a deep change in organizational culture is to be expected. Engagement with stakeholders is to be affected, naturally. The obvious consequence of disclosure is that shareholders and the general public as well will be able to monitor the implementation of sustainability concerns on invested entities. And of course, this will trigger consequences for corporate bodies. Duties of care by administration, management, and supervisory boards are now enhanced and encompass due attention paid to sustainability matters and careful weighing and balancing of contingencies surrounding sustainability risks. direct and indirect consequences stem from this responsibility and liability. On the one hand, direct penalties for failure to comply with reporting duties will arise pursuant to Article 51 of the Accounting Directive. On the other hand, failure to comply with reporting duties can in turn imply responsibility by administrations for not adhering to such due diligence standards should a risk materialize. And such risk can have, for instance, direct impact or consequences on the undertaking's business, since failure to effectively report environmental concerns can affect credit risk assessment of an undertaking or even lead to a counterparty risk warning in certain contexts that are more prone to devote relevance to sustainability factors. Obviously, all of this can lead to responsibility for breaches of duties of care of directors towards the company and its, I would say, stakeholders more than shareholders. In short, one must conclude 4 bullet points that first, the EU's own sustainability standards might differ from those that have been followed up until now as industry standards, both industry generally speaking and other jurisdiction standards. Second, there is a significant asymmetry of reporting obligations and implementation regarding non-EU firms. And one must stress that the vagueness of reporting obligations is still to be stressed, still to be committed, especially when the undertaking has obligations of reporting environmental concerns and risks that it identifies throughout its value chain, of course, which in turn generates significant issues when we apply these norms to groups of companies, which are, let us put in this context, let's say all of the undertakings are included in groups of companies. Third bullet point, compliance costs will increase. Fourth bullet point, new governance issues might arise. All of these bullet points stem from what we have stressed in the beginning, from a political desire of the EU in leading the field when it comes to ESG matters. It is clearly a political decision. Such decision might be more or less welcome depending on the commenting sector, but definitely will deeply impact companies, definitely will impact their culture, even the pursuit of company purpose, and of course, the duty to report financial information. And I thank you for all of your attention. I hope that we were able to once again bridge the distance using the video communication. I wish I was there with you once again, but I salute everyone and thank you very much for your attention.
Thank you very much. Although at a distance, it was really clear and enlightening, your presentation. So thank you very much. And now we would open the floor to the comments. I would suggest that Paulo Câmara starts with his first comment, and then we will move on to Bruno. Thank you.
Thank you so much, and hello everyone. My first words are to thank for the invitation to be here, to greet my colleagues of the panel, also Flip, which is watching from Porto, and I will address Madalena Prestrelo de Oliveira. Brilliant presentation here. I had the privilege of having access to a written version of the presentation, and so my first words, of course, of praise. It's a very well written piece, very timely, and a must read really for those who are interested in knowing anything about sustainable corporate governance. So please do access it as soon as it becomes available. It really is an instant classic for these fields. Of course, the topics are the interrelation between sustainability and corporate governance, and we are witnessing a period of change, of deep changes in that respect. Changes in terms of the purpose of the corporation, as we have seen, changes in terms of the board duties, in terms of the risk management, because you have new risks to manage, both environmental risks and social risks. We have changes in terms of the perception of the reputation of companies, in terms of its reporting, and in terms of remuneration. So, I mean, all the core elements of corporate governance are very much into evolution, and this will go on through the present decade. I mean, it will be a decade of changes, and stability and sedimentation will have to wait for a while. Now, the first comment has to do with what I think is a change of the concept of value, because Madalena Prestello states, and rightly so, that the core function of corporate law is indeed enabling the creation of corporate value. And what I think here is that we are witnessing also an evolution in terms of what is value and what is value creation for companies. And I think this is at the core of the debate. As we have seen from this presentation, the EU terminology is evolved from talking about financial and non-financial information now to be addressing financial and sustainability reporting, which means that the sustainability aspects of the company are not outside the scope of its financial impact. They are intrinsically linked to value and to value creation. And so this is very important when you see the perception of consumers, investors, and even workers from the company that attach value to the options and decisions that are taken in terms of sustainability. My second comment refers to the perimeter of topics which are included in the subject sustainable corporate governance. And here it is very interesting to make a test, which is paying attention to the recent reporting sustainable standards, the ESRS. So this is very recent, and we have one standard which is specific on corporate governance, which is ESRS G1. It says G1, but it's the sole governance standard. And this standard has a list of topics which are considered by the European lawmakers as the core topics which are relevant for sustainability. And they are corporate culture, relationship with suppliers, corruption and bribery, so prevention of corruption and bribery, prevention of lobbying and political influence, and payment practices. And so I think it's very striking that in a very revealing, it's a benchmarking exercise of disclosure of governance practices, we don't include anything on conflicts of interest, on relationship with workers, for instance, or you have the yes part on that. I mean, and all the basic structures are obliterated, or most of them are obliterated in that presentation. And so I think we run the risk of having a biased picture of governance that will stem from sustainability reporting practices according to the ESRS G1, and that is almost a paradox. For instance, you have relevance to the treatment of animals, but you don't speak about conflicts of interest. So this is the first question that I want to pose in terms of the evolution and the perimeter of topics that we have to address. Second message concerns, and this was very well described, the articulation between shareholder value and stakeholder value. Now, I don't think these terms are adversarial, and I don't think we should take those as part of a zero-sum game. If you take out of the shareholders, if you give some more to stakeholders, the meaning you are taking out of shareholders. I think the logic should be building value for both shareholders and stakeholders. And if you go back, Madalena, to what Milton Friedman said, of course, he presented a huge criticism to social responsibility, but he states at one point that we should not blame a sole proprietary, meaning a concentrated ownership company, if that company decides to deploy social responsible practices and policies. So it's very interesting because his main issue has to do with legitimacy of the decisions taken by the board. And so the alignment between the board and the shareholders, which applies mostly to fragmented ownership companies. But if Friedman were to address concentrated ownership firms, he does not pose any criticisms to stakeholder value creation. And so it is something which is not one block against the other, but I think we should view it as a system where everything interacts. Of course, there are, in some occasions, and I agree with that, you have to make choices, and there are, of course, difficult choices because, for instance, when you make some environmental related investment, you may have social costs of those investments and financial costs, of course. Very interesting, the case of Lego. I don't know if you heard it. They began planning a major reshuffle of ESG-oriented changes of the structure, but they came up to the conclusion before executing it that the cost for the environment of having new plants and new facilities was in fact much higher than keeping and making some adjustments on the former plants. And so I think that the analysis of costs and benefits is much more complex than just saying, well, give one to take the other. Then the notion of stakeholder and Madalena Prestrelo's views is that we should pay mostly attention to the non-contractual stakeholders, and I would challenge that view on the basis that, of course, and your paper is very clear on that respect, there are very relevant stakeholders which are contractual stakeholders, and you named the example of workers. But even in this framework, and the relationship with the value chain becomes central, and the value chain comprises mostly contractual stakeholders. Of course, there is a non-contractual stakeholder, which is the environment, and that is a very important topic. And of course, if you look at the environment as a stakeholder, you probably have to have an adaptive interpretation of Article 64, or you have to change Article 64. Your view is that we should keep it as it is, as I well read your thought, but I think that the sole stakeholder that defies the primacy of contractual stakeholders is environment as a stakeholder. Secondly, I mean, these my last points are the notion that companies should not profit by causing problems, and here, of course, I think that the very notion of causing problems varies over time. This is something that you addressed in your paper. The defense industry was looked some years ago as a brown industry. It was non-sustainable. It was almost what is called the sin stocks. Defense stocks were seen as sin stocks. Now, after the war on Ukraine, we see it at a very different light. Again, and so this means that the very notion of problems is evolutive. It's very difficult to have a stable concept around that notion. And you mentioned the book of Colin Meyer. Colin Meyer basis is very a notion of purpose around avoiding to create problems, but he was never clear, in my view, of course, on defining what problems are in that respect. For instance, you have companies that work in the leisure industry, like tourism or hospitality, and does that mean that, well, they are not solving problems, they are not problem solvers, but does that raise an issue, or that's on the definition of purpose itself? Now, my last point deals with your keywords: purpose, practice, performance. And I think that those are very catchy keywords and a good to be a summary of what is at stake here. And when we come to performance, I will have to talk about culture, because performance is not just the tone at the top, not just the narrative of board members, which are enlightened and inspirational leaders for the organizational. I think it's very important that the values of sustainability pass over to the whole organization, to the whole company and the whole firm. And at some point, I think you imply that culture influences board members. But here, I think we should draw a distinction, because there is one thing that I call the macro culture, which is the social pressure, the pressure from investors, the pressure from ESG ratings, proxy advisors, and of course, this is a big melting point that points out to the systemic nature of the factors that pressure sustainability decisions. And so I think those are external drivers of the culture. But one different thing, of course, is culture as a product of the company. And here, basically, you have that culture as a responsibility of the board members. And so I think board members are, of course, influenced by what I call the cascade effects, the systemic forces that drive sustainability from the outside world, customers, investors, rating agencies, regulation, reputational devices. But then when you come to the micro system of each company, then it's a duty of the boards to be implementing a sustainability culture as a culture that involves the whole organization. And that, I think, is the ultimate test. Besides reporting, besides compliance tests, I think when you say purpose, practice, performance, I think one very direct way of translating performance when I talk about sustainability is to build a sound, robust, sustainable culture for each company. That's it. Thank you.
Thank you very much. Would you like to address these comments right away, or should we first move on? Okay, so Bruno, would you have the floor?
Thank you. Sorry. So thank you very much. Thank you for the invitation. It's a great pleasure to be here today and to be able to hear these very eloquent presentations, and also very interesting, of course. Especially because these days, and first I'm sorry I won't be as organized as Paulo. And so I think then it's good that you get to answer both comments at the same time, because mine will be here and there. Especially these days where we feel and appear to be on the other side of the pendulum rocking. So I think that, and Madalena's presentation on that was very interesting, because of course both extremes of the pendulum aren't exactly stakeholder capitalism and shareholder wealth maximization, because both of them contain elements that don't make them as the extremes of both the pendulum swings. But we appear to be in certain parts of the world on one end of the extreme of the pendulum, and this does tend to be floating from one side to the other. So this debate is very, very interesting. So the first topic I would like to talk about is on the reporting directive. It does imply a huge change in some of the issues. I do feel that, especially from a process perspective, it will be making a significant difference in terms of how companies approach all of this sustainability related issues, especially in one of the points in the double materiality perspective, in terms of figuring out what's the impact that the companies are creating, and on the other side, what impact will their business activities be suffering from, for example, climate change, rising sea levels. So it's to be expected that at least a company that operates hotels will be considering when they build a new hotel right by the ocean front. So I think that will definitely change, but even though generally I'm an optimist in relation to these topics, I feel that the reporting directive will probably not work, not as much as it is expected, especially in those jurisdictions, smaller jurisdictions in the EU, such as Portugal. And my comment would be that in country, and Portugal is a case in point in that, in countries in the European Union that have practically no market for corporate control, countries that have no actual class action mechanisms, or if they do, they're still incipient, they work in some areas, and now we're witnessing that in some areas here in Portugal, but we don't have class action mechanisms. We don't have investor activism, and most of all, and I think more importantly, we tend not to have a social norm that people incorporate in their day-to-day business in managing companies when it comes to, so some companies have, but not a lot of them have. So my big question here is, do reporting mechanisms, even if they are more detailed and they have an expanded scope in terms of coverage, will they work in jurisdictions with the characteristics of the Portuguese jurisdiction? I'm not very optimist. I'm very pessimist on that. What I think is a better mechanism and regulatory mechanism is what is being done currently in the due diligence directive, which is a piece of regulation that, I mean, depends on the outcome and on the final version of the directive, but according to some of the initial versions, is something that will have regulatory teeth, so to say, meaning that a lot of the enforcement mechanisms will be already included in the directive, and probably might have an impact, even if for Portugal they might also be involved, might also have the problem that the reporting directive has in terms of low enforcement and low social norm in terms of a conviction that regulation should be complied with and sanctions should exist if people don't comply with regulation. One of the additional issues that I have, or the doubts that I have in relation to the reporting directive, is the extent of the inside out view that should be, or investigation that should be taken by the company. Of course, one of the, and this was very well described by Philippe in his presentation, the fact that now that there will be a change in the company governance, and that companies will need to identify the impacts that they're creating. But, and this is also one of the debates in the due diligence directive, is how far does a company need to go when it investigates, and the impact that it's having? Is it the direct impact, the impact that its suppliers are having? And especially, which I think is one of the biggest issues and biggest doubts around this whole value chain impact, both reporting or due diligence, is trying to determine what the impact will be in the companies that produce or manufacture items that will have a damaging effect, even if used correctly. I think one of the the big difficulties is that if a company produces something that creates an environmental damage, it can always say, well, this creates an environmental damage, but I'm hoping that people recycle. But it's basically shifting blame to the customers and to the clients, and not to the company that's making and profiting from the products that it's making. So I think that's one of the big discussions we'll be watching, both in the reporting directive and the due diligence directive, is that people will need to focus, and businesses will need to focus on what they're producing, and they cannot expect to shift the blame to the consumer and expect the consumer and say that this product will not harm the environment if it's properly recycled or if it's used in the correct way. And because we know it's generally recyclable but not recycled, so that's one of the big issues on that. And on a last note on the whole stakeholder shareholder debate, I also feel that we should stop blaming Milton Friedman. It's the title of the very famous article, because if you continue to read the rest of the quote, he then goes on to say, I'm making it up. The responsibility of a business is to make as much profit as possible within the acceptable social parameters, and those rules have changed because it's a perception. It's according to whatever public opinion thinks is acceptable, and so at the time, of course, this was a big debate. First of all, this was only a New York Times article, but then, of course, it created a big impact because it came from decades of discussion, and of course, the way that board members and directors are paid and what the incentives were created for this. But most of all, it was a socialist versus capitalist discussion at the time. So if we look at it right now, we can say that even people that think that Milton Friedman was right, they should adapt the analysis that was being made at the time by Milton Friedman and analyze it according to what is public opinion and culture and what we feel is damaging. My biggest concern is that the whole debate about the director's duties at the end of the day will be very difficult to enforce, especially because of the business judgment rule. I think that it's the reason why the business judgment rule exists is to avoid courts from second guessing business decisions because of the hindsight bias. And so each time we go into that discussion, either it's a hard and fast rule saying that you can't do this, or if it's a more generic concept, it's going to be difficult to enforce. So I think that because we probably don't have time today and don't have time as a civilization, the discussion will need to shift to certain damaging activities will have to stop being profitable. So either if it's because they're taxed or for some other reason, the business case decision needs to have certain limits because of the impact that it's creating. Otherwise, it probably won't take us there in time. Sorry for not being very organized on the comments.
Thank you. First of all, thank you so much for all keeping within the short time frame we have. I suppose we have time to open the floor to debate. So if anyone has any questions you'd like of course, you first have to answer. Sorry about that. So you go ahead.
Yeah. So firstly, thank you, Paulo and Bruno. Paulo, for your kind words, but especially for the very useful comments you've made. So maybe I'd like to start with the idea or the concept of value. And you said something like there's an evolution in terms of what value creation means for companies. And I fully agree with that, of course. And I believe that we've come to a time where we need to acknowledge and think about actual value creation and not value transfer, because what sometimes is looked at as value creation is indeed value transfer. Because if we think about cash being paid out to shareholders rather than used on research and development activities, for example, that would obviously grow an existing business, no real value is being created. What is happening is value is being transferred from one stakeholder to another. If we think about moving corporate headquarters to a low tax country, no value is being created. Value is being transferred from one stakeholder to another. So it is true that the idea of value has morphed, has changed over time, but companies really need to look at value creation and not just value deviation from stakeholders. So you also said that you mentioned the ESRS, ESRS, and the idea that we are gaining a biased picture of corporate governance. And I would agree with you, firstly, and I would add that's very, we need to address that issue, because I really believe that when we look at corporate law, at financial law, we know that the cornerstone of financial regulation is disclosure. We believe, I'm saying we, I assume that you would agree with me that we believe in the functioning of market, of free market. And so the EU approach to regulating financial institutions and financial law in general is by means of disclosure. We believe that companies should disclose ad hoc information, material information that has relevant impact on financial instrument prices, for example, because we believe that information has a direct impact on the formation of prices in the market. And by that disclosure, we protect the markets and then we protect investors. So this is basically the idea behind the efficient capital market hypothesis. And what we are looking at, what we are watching nowadays in EU regulation is a shift from the reasons behind disclosure regulation. So until a few years ago, we had disclosure regulation aimed at protecting markets and protecting investors. Nowadays, I would say that sustainability-related disclosure obligations are intended to point companies in a certain direction. And so this comes making the link between what you said, the idea of giving the market a biased picture of governance is very important, because this means that companies are only being nudged in a certain specific direction that does not acknowledge certain other stakeholders and does not faces other problems that should be disclosed, and then that would probably make companies go, maybe not now, but in a few years, transition in what is considered the right direction, even though, of course, we don't have a universally valid concept of that. The idea of stakeholders and the idea of non-contractual stakeholders, and to the core of what you said, to be perfectly clear, of course, I value the need of protection of contractual stakeholders. My only idea is that those stakeholders are already protected by specific regimes, like employees have labor law regimes, other stakeholders have the specific contracts they entered into with the company, and so on. But when we look at those stakeholders without a contractual relationship with the company, like the environment, local communities, and so on, then the problems are even bigger and even more pressing. Of course, this, and if I may circle back to Bruno's comments, that was about something like you said that companies should not profit from negative activities. And you said, well, that companies should be taxed for those activities and so on. And well, even though I agree with you to a certain point, I think that undermines the value and the importance of private law, because what you are stating, in my opinion, is that it is not the function and the scope of private law to protect these kinds of stakeholders. And well, I believe that it is the purpose of private law to be a catalyst for change, to no longer be a neutral organizational system that only says, well, we have these corporate forms, we have this corporate organization. We need to push private law, and especially corporate law, into well, a value committed system within the private law. And so, of course, yeah, probably we should tax some activities, we should think about some other solutions, but we should also look at the role corporations, companies have to play in this market. So and of course, we are still talking about capitalism. This is all capitalism. We're just speaking about a conscious or a responsible capitalism that implies a corporate culture shift. And well, I agree with you. Of course, we have these external drivers of culture, regulation, disclosure obligation, ESG ratings, as you mentioned, and we have the inward idea of corporate culture. But and well, we are also all of those who are sitting here today, we are also lawyers, and we are corporate lawyers. So we know firsthand the resistance that board members have regarding these issues. I personally have faced that resistance in discussing these subjects. And so we know that, of course, regulation isn't enough. We need corporate culture, and regulation cannot shift culture. That's true. But I truly believe that regulation may nudge companies and may push, more than nudge, maybe it may push them into a more sustainable path. Because we all know the impact that soft law mechanisms have on corporations. Everyone wants to comply rather than to explain why they don't comply with soft law principles. So if we talk about hard law and regulation, no one will want to disclose, well, yeah, we don't care about the environment, our workers, and so on. And so the last thing I would say is you stated that shareholder value and stakeholder value are not adversarial. Well, I believe sometimes they are. It's great when they're not, and sometimes we see that shareholders are the one pushing from inside the company for changes. We see that, for example, on the Say on Climate initiative, where we have shareholders passing or trying to pass resolutions at the General Assembly towards a climate transition within a company. And so sometimes we actually have this alignment of interest between shareholders and stakeholders. But sometimes we do not, and many times we do not have this alignment. Of course, I wouldn't say they are adversarial, but sometimes they're not aligned, and we have to assume that they're not aligned, and we have to say to our directors, well, even when pursuing a course of action that's not the best one for shareholders, provided that we ensure financial sustainability, of course, that's always the premise. Well, you can decide in that way. You can choose a direction which is not the most profitable one to shareholders, because it is the right one for that local community, for environmental impact, and so on. So to sum up, and without prejudice to other questions, I would say that my main takeaway is that, well, I believe that private law has a role to play in the sustainability path. It must have it needs to have a role to play. I don't want to sound naive. I'm optimistic. I don't believe in a complete revolution of directors' fiduciary duties. I believe it is probably the interpretation we should have today, facing our specific environment, society, etc. We should interpret directors' duties in a way that encompasses also acknowledging other stakeholders' interests, including the non-contractual one. And acknowledging them doesn't mean just to say, okay, box ticking, yes, we consider the environment and our workers, they're all very happy. No, it's actually having more than someone, having people on decision-making positions, not only within boards, but in management positions that are able to incorporate those issues into decision making, to actually discuss them and decide in whatever way they deem appropriate. Of course, in the end, it's a discretionary decision, and we have to accept that. Thank you.
Thank you very much. Philippe, are you on? Can you?
I am. Thank you.
Okay, so do you mind replying to Bruno? Is he
No,
right? Is he
how-
wrong? What do you think?
How could I mind? With great pleasure. First and foremost, thank you, Paul and Bruno, for the comments. I will try to be brief once again. Madalena has provided us a great tour de force, let us say, with the values underpinning all these problems and the principles and the jurisprudence behind the reshaping of corporate law. So I will try to address Bruno's comments specifically. I noted, I always like when quotes are placed in their context, and so I salute placing Friedman in context, just for the sake of placing everything in context. I always like thinking of justice matters as always implying thinking of the context of the discussion. This is something that, for instance, Rainer Forst, he has a huge work named Contexts of Justice. When he thinks about jurisprudence, he's actually lectured with Habermas. So it's a sociological approach of justice, and he says that we cannot think of any legal problem without imagining the context. And I think that from what we've seen specifically, Paulo mentioned the Union Sustainability Reporting Standards recently out in July. Bruno mentioned the Due Diligence Directive. We are seeing that some of the most, let's say, specific, tangible initiatives that we are discussing here are mainly proposed, brought forward by European lawmaking procedures. And I think it is important, first and foremost. Of course, this is a wide-ranging, I wouldn't say issue, I'd say a wide-ranging matter. All jurisdictions are dealing with sustainability matters differently, but the EU is sort of leading the way. And this is the first point that I try to pass and to make. The context of the European Union is quite important. I would say that there's an European Union context that provides a political mandate, let us say, or a political intention to protect consumer rights, social protection, and I would say that corporate sustainability is just another pillar of all this idea of social intervention by the European Union in society as a whole. And corporate sustainability in this regard is not only being, it's not only in the spotlight for corporate law purposes, strictly speaking, but also for tax law. For instance, the European lawmaking procedure is now studying, I would say, 6-7 directives that address tax issues. For example, Madalena mentioned changing the corporate headquarters. That, for example, under the new anti-tax avoiding directive 3, that will be very complicated to do unless you have very substantial reasons to do so. All tax effects will be denied. It probably won't go further ahead, but this is just to say that, in fact, the corporate world is under the spotlight for sustainability purposes, and this is, I'd say, more than a mere nudge, as we were concluding in the comment, in the previous comment. So I would just address 3 issues. Now, Bruno mentioned that this carries indeed a huge change, and I'll try to wrap up or to sum my view on his intervention, starting by mentioning that this brings a huge change to corporate culture. I think that this can impact, by this I mean, of course, corporate reporting, can impact business judgment rules and its interpretation, in the sense that it implements procedures, and procedures need to be adhered to. I was once told by a scholar of a different area, not a legal scholar, that, well, you lawmakers, you like to resort to proceedings when you cannot define what a material concept, and so you fall back to proceedings. But this is indeed a nice way, or let's put a way to interpret these senses, right? Let's bring down a procedure that allows people to think about sustainability issues, and let's hope that in the process they effectively address them. This is, let's say, the material part of it, but the impact that due diligence procedures have in interpretation of business judgment rule, I think that it cannot be disregarded, especially when we think of implementation or the connection between the reporting directive and the due diligence directive. Because if indeed the due diligence directive is to provide regulatory teeth, as Bruno's mentioned, to its dispositions, and if we sort of consider that environmental and sustainability issues, and I would just like to add that sustainability is not only about environmental, it is about employee concerns, it is about value chain concerns, it is about anti-bribery concerns. These are more financial concerns, let us put it this way. But as I was saying, if one considers that sustainability issues become a part of a due diligence procedure in managing a company, and if one considers that due diligence directive can give regulatory teeth to whether these concerns are addressed or not, we may be in for a big change, especially in corporate culture. This is my main takeaway here. I would say that corporate culture can be deeply impacted by, especially by the procedure of data collection. This would expose sustainability issues to all fields, all tiers of the company context. And I think that this can bring a change right from the beginning to the corporations on their inside. I would sum up just by saying that I was prompted to say whether I agree or disagree with Bruno, and I would say that I agree when I say that when it's mentioned that perhaps the relevance of these reporting requirements is, let's say, well, maybe not as extensive as it is in other jurisdictions. In the case of Portugal, its relevance might be diminished. This is mainly due to the dimension of our economy. Of course, there may not be many undertakings. Let's start reasoning by this. Use this as a measure. There may not be many undertakings that are subject to these reporting directives, but nevertheless, I think it can impact Portuguese companies and Portuguese corporate community both ways. One, as I was saying, through the changes in procedures that then must integrate every board decision-making process. And also, if one considers the so-called double materiality concerns, there may be issues where corporate reporting might impact the day-by-day. For instance, when we consider financial materiality, by financial materiality we mean environmental or sustainability concerns, better said, that impact financial decisions. If one can identify sustainability risks that might impact future cash flow of a company, we have there an issue for the company. For instance, whenever it comes, I think that credit rating is the most obvious example, but also credit insurance can be used as an example of measuring of a company's risk. We now live in the world of algorithms. Who knows what can be embedded in those algorithms whenever you throw in the reports, the sustainability reports for them to churn. But also, when we think about the impact materiality, when we think about the reporting items that relate to business relationships and the relationship of the company with stakeholders, there are some requirements concerning disclosure of value chains and contractual value chains that might impact a company's day by day. And I have a specific example in mind. As Madalena says, we are all corporate lawyers. I also work with, and I'll be brief, I'm wrapping up. I also work, for example, with textile companies that sometimes are not able to supply foreign purchasers because they demand them to adhere to certain norms, certain standards required to sustainability, for instance, requiring with employee compensation or certain purchase of materials. If this becomes embedded in general law and norms that relate to these types of standards become embedded in general law, this can impact not only, let us say, the stakeholders, but the own functioning of the company, forcing it to adhere to, I would say, different normative standards in lack of a better term. Thank you once again.
Thank you. Thank you. First of all, thank you both of you for addressing the comments. I think we're all very clear. According to the organization, we still have a couple of minutes for some questions from the audience. Do you have any questions? Do we have a microphone? I don't know. Thank you. This is what we call an all-purpose lawyer.
Hello, I have two questions. Reminding the CSDD, the due diligence directive proposal, and I wanted to ask if isn't the purpose of the CSDD to be applied to companies that have a significant footstep in harming the environment and human rights, with the determined volume of business in the European Union, and isn't it kind of irrelevant that the culture of investments, for example, in Portugal, because the member states in that directive are only applied to control that companies respect and they not respect that they follow that due diligence duty. So I think that's important that the investment, the volume of investments in a country isn't that relevant because of precisely what I said. The states just need to control that that the due diligence duty is respected in the member state. The second question.
You have to make it short,
Okay,
otherwise
okay,
we won't
sorry.
have time to address it.
The second question is related to the Article 64 of the duties of the
Portuguese Companies Code.
Yes, and for me, I think it's also a matter of interpretation because the sustainable interests are there. But as the professor said, Paul Kammer said, that change could happen with altering the
Changing the wording.
Yeah, exactly.
Okay.
And I would want to know how would that be possible and how would that.
Thank you. Thank you
you,
for the
sorry.
question. So I suppose this is a question for Philippe. So Philippe, 2 minutes. Can you address both questions, 1 minute each?
I would suggest that Madalena addresses the Article 64 question, since she specifically mentioned it in her presentation, and I will address the first question, if that is okay with Madalena. I can see the...
Okay, perfect. And Madalena will address the second one.
Yes, you know, I think it can be more interesting there. Well, concerning the scope of the undertakings that are subject to this directive and the relevance to the Portuguese community, I hope I addressed the concern of the one posing the question. The issue here, first and foremost, is that the size of the undertakings that are being forced to report is not that huge. When we are discussing that a large undertaking exceeds 2 of the following 3 criteria, we are saying 20 million euro of a balance sheet, 40 million euro of net turnover, and 250 employees during a financial year. This is the definition of, I almost say mid-cap or a small mid-cap. I don't have it present at heart right now, but this means that a definition of a large company for this purpose will include some of the Portuguese companies. So this affects our community to a certain extent. And then I wouldn't go as far as saying that obviously what concerns me more is not exactly the relevance, let's say, from a public law sphere, but it is the argument that stakeholders, or for instance, creditors or shareholders, can take from the reporting duties. By arguing that reporting duties are not correctly fulfilled, that risks that were identified were not carefully addressed by the company, or that the management board failed to identify certain risks, you open a door to saying that the board, the management, failed to comply with its duties of care and loyalty. And from a governance perspective, I think that is more impactful, at least if we're thinking from a private law perspective, even than considering the regulatory power or teeth, as was mentioned, that these provisions might give to authorities. Thank you. That would be it.
Thank you. So Madalena, would you address the second one?
Yeah, thank you. First, thank you for your question. I'll be very short. Of course, the question is very complex and it would require a lot of debate. The other day, Paulo organized Congresso dos Valores Mobiliários, where in the second day we discussed that possibility of changing corporate law. And the idea at the end of that conference was that there were many people that would argue for the change of Article 64. And I think that Paulo has a point when he says that non-contractual stakeholders would be probably hard to include in the director's duties, considering the list of stakeholders that are in the Article 64. My idea, let me be clear, I'm not against per se changing the wording in Article 64, even though I believe it isn't required. My main idea is that we have a bigger problem, and the bigger problem is the way the whole company law system works, because shareholder power, the way they influence, or the power they have in electing directors and so on, is probably at the core of the issue. So of course, if we have a cultural shift, a global cultural shift in investors and within the company and so on, this problem that I'm exposing here today wouldn't probably be considered a problem. So maybe the core of the issue is actually changing corporate culture in order to go this way. But to be clear, not opposed to changing the wording, just I think we need bigger changes than just a wording change in our Portuguese companies code. Thank you.
Thank you very much. So I suppose we are running out of time. So I would ask you for an applause for all the... Thank you very much, all of you. So I would conclude this panel. I suppose now we will have the concluding remarks by Professor Carla Amado Gomes and Luís Oliveira and Professor Madalena Paz Ferreira. Thank you. Paz Ferreira.
So it was a very interesting day. This conference, I think it was, we can consider it as a success right now, because debates were very intense and fruitful. I repeat, I learned a lot today. I'm not sure environmental law will be swallowed by private law. I commented with Eloise that it's probably going to be a little like the runaway to private law, which administrative law faced some years ago. And everybody said administrative law will be destroyed by private law. It will be swallowed, it will disappear. Now we see that it's not that. Private law was absorbed by administrative law. And so using this precedent, I may say that probably private law will be adopted by environmental law, which is a soft way to put the question. But anyway, rivalry apart, I thank you so much, Madalena, because it was a task, a huge task to build this, and of course nothing would be possible without this force of nature that is here beside me. Luís Oliveira, she is really the most determined person I've ever met, for the good and for the bad. And I thank you both so much, and all the team that supported this conference, and thank all the speakers and the commentators that were here and online, of course. We were saving this last minute to address a very, very dear question to us, which is the advertisement of the launching of the publication of volume 3 of the treatise on environmental law. We are already seeing the front page. This volume 3 is dedicated to environmental law and other legal fields. It was difficult to build it. It was difficult to join forces in both private and public law. It's not complete. It will be developed next year and the years ahead. It's a work in progress. And now that we reached the first version of the third volume, I would really like to say that, of course, Madalena was fundamental for this third volume. But once more, I have to thank Eloisa. I know she doesn't like it, but she's worth it. I have to say this because, quoting Martin Luther King, which is sort of a cliche, but anyway, I had a dream some years ago to make, not this, it was not so sophisticated as this. This is all her idea, but I had a dream of writing a treatise on environmental law in Portuguese for the Portuguese public, which would have mainly what volumes 1 and 2 have, the general part and the sectorial parts. And I tried, I invited some people, all very enthusiastic, but at a certain point I realized I didn't have enough people to write it. And I couldn't assume that task because it was too much. And then, I wandered through other fields. Who knows me know that I play in the green field and the red field, which I say it's administrative law. And I dedicated myself to organize commentaries on the main administrative laws we have in Portugal. And I think we did a great job. I, Tiago Serrão, and other colleagues on the red field. But this dream was yet to fulfill. And with Eloisa, it all looks so easy. And she brought the determination, the force, the brilliance to this work. And she would be what she is without me, of course. I have no responsibility on her brilliance, but I can say that I am so proud. I put the seed in this school of law. I put the green seed, and I could leave now because she would go on perfectly without me, and other colleagues also. And this treatise will always be a testimony of that seed and of our work. As I say, it's yet to complete. It's going to be years ahead, and it's digital, so we can always change it much more easily than if it was on print. But anyway, it's a huge task that ends today on the first version, and will go on until we have the strength to get people to write and get mad with details and with texts also to write. I have to make a mea culpa here. I should have written in this volume. I wrote in the other two, and I really couldn't. It's one of the few times in my life until now that I fail a compromise I had with myself and with this work, but I will, and that this is a public statement, I will write it with Eloisa next year. But it's someone said that we have to be humble, and this kind of situations tell me that I have to be humble, and I have to realize that I can't do all things sometimes, only sometimes. So I'm very, very, very glad. This is the best birthday present I could have, these treatise, and I hope you take a lot of profit in reading it, and as much profit as the work it gave us to build at least. So thank you so much. Then I will let Eloisa and Madalena say other more interesting things now. Thank you.
Okay, thank you. Now I'll be more objective. So this is the third volume, like Carla was just saying. So it's about 1,500 pages, not this volume, but the whole work. But actually, this volume has 10 chapters. There are about 10 chapters missing. So, but we did what we could. So basically, and this is, we really have to highlight this. It was very, I felt at first it was very ambitious, but we could do it thanks to Madalena, which is we need to add private and public law together. We can't keep doing this separate waters thing. So basically we have 5 chapters that are essentially public law. So Armando Rocha, who is also here in the morning with, well, me, on human rights and fundamental rights. Mateo Fermelia, who's sitting over there, on international investment. Maria Pena Ermida from Católica, who wrote a chapter on fisheries. Miguel Assis Raimundo on public procurement, of course, always a very hot topic. And Safira La Sala and Rachel Alterman on land property and urban planning. So this is the sort of public law part. And then we have 5 chapters on private law, Madalena.
Okay, thank you. So, sorry, I'll have to circle back to a less objective something I need to say. So, thank you, Professor Carla Amat Gomes. Thank you, Eloisa, for this very kind, very generous invitation to join you in this 3rd volume. It's an honor, truly an honor to have this opportunity to edit and to help make this baby born. And I truly believe in the importance, as Eloisa said, in the importance of, well, I really don't mind that we're moving towards something like private law being neutralized by environmental law, even though I don't believe it. I really don't mind listening to it. I think it's part of the debate. And well, linking it with this index, I think the importance of having these five texts on private law is the idea that I was just stating, that we really need to embrace the idea that private law has a role to play in the sustainability issues. We need to acknowledge that private law is going through a very delicate change in forces, and we're probably watching what I would say a publicizing of private law, and that's not a problem. That worries corporate scholars very, very much, and they say, well, private law, it's not its role to pursue sustainability and to pursue climate goals, etc. But I think it's a good way to go if we're going in the right direction. So I'm okay with the ideas that were just stated, as long as we're doing this, we're going in the sustainability path. So okay, so chapter 6 is about sustainable corporate governance. It was written by me, so you have a global idea of what's written there. Of course, there's much more to say than what I presented in 20 minutes. Some of it's in this paper. Unfortunately, many important aspects are not. The next one, okay, so corporate sustainability reporting, a great paper by Professors Maria de Fátima Ribeiro and Filipe Cerqueira Alves, thank you, and Filipe Cerqueira Alves. Of course, you've just heard them. Chapter 8 explores sustainable corporate finance. It was written by Professor Ana Prestrela Oliveira, and it investigates the incorporation of ESG factors by stakeholders, the global shift towards sustainability in markets. And chapter 9 dissects the impact of environmental and ESG factors in financial law, spotlighting the taxonomy regulation, the sustainable finance disclosure regulation. It is a great paper by Joana Gomes and Shen, who you heard today. And the final chapter, chapter 10, explores the nexus between environmental law and consumer law. And it makes a very interesting relationship with legal paternalism and introduces the idea of sustainable consumption, and it questions how is it embedded into current regulation, into current framework. So I really recommend reading. Thank you. That's it.
Okay, thank you. That's it from us. This will be available in about 1 or 2 weeks. We're just, making it beautiful. So it will be available online, open access, and since you have registered for this conference, you will receive an email about it. So, and that's it for today, right? Okay then. Bye.